Well, in item 34, on an affidavit is in file. Kindly allow me to call. I'm filing.
Okay.
With regard to item number 4, your item number 4, I'm for the respondent fully.
Item 4.
I've taken contact from the petitioner
For consent.
after that.
May I please, may I please,
Yes.
the big mention item number 5. In
Yes.
this case, Mr. Prakash is
Uh-huh.
Mr. Prakash is appeared. Name
Okay.
is not put in the consent.
Okay. Thank you.
I pray for listing of on bail application tomorrow.
Bail.
I've already filed.
I think you should mention
No, the lottery they have already rejected it.
reject. Okay. Okay. Okay.
We had the matter, but not today.
Ah.
So tomorrow, I don't
Not listed.
just be that diary shows that 21, but not.
Okay, we'll verify. Give the mention. Ma'am.
What's the document? Item number 7. Only
Uh-huh.
item number 7. Not finally, I don't know detail.
7. For the petitioner.
Okay.
Adjourn.
Your lordship, item number 6.
Yes.
Accommodation lordship after vacation lordship. I've taken the consent.
After vacation.
Six.
For the respondent number 1.
Your
And
lordship,
after.
your lordship, I beg to mention item number 8 with the consent of
Yes.
for personal certificate of senior.
You are for a petitioner?
It is
Adjourn.
May I please, your lordship, I beg to mention item number 12. Kindly pass over the
For a petitioner? For the petitioner, adjourn. After.
May please your lordship, I beg to mention item number 17. Appearing for the petitioner with the consent of the opposite party.
Okay.
Maybe listed after the vacation.
After.
May I please, your lordship, item number 25. Can it be taken up on 4th of January? CD is available. Senior 20.
CD after vacation, give a date. 4th.
Oblige.
Yes. Mistake. Mistake on who committed the mistake?
Typographical lordship, inadvertent lordship. Page 12 is the order lordship. Paragraph page 14 is the operative purpose. Considering the nature of the offense, inasmuch as the period of the sentence it is preferred that the applicant shall remain on previous bed in connection with the impugned judgment dated. So it should be impugned judgment not to pass with the CGM lot. But this order was
Okay. Comma. Correction is required is made. लिखी दियो पहले एक करी it is submitted that there is a typographical error in the order dated 25/8/2023 passed in IA Criminal 749/2023. In the last paragraph of the said order, instead of judgment is same, instead of learned session judge.
no judgment date is different case number.
Okay. Instead of
What do I have stated in my
instead of judgment dated, where is that statement?
Page 5.
Yes, 5. Instead of
Inverted comma with inverted comma.
instead of judgment and order dated 7 instead of judgment and order dated 4/1/2021 passed by the learned Chief Judicial Magistrate Dhubri in GR case number 704 of 2021, the same has been reflected as judgment and order dated 17/7/2023 passed by learned additional session judge Dhubri in criminal appeal number 02 of 2021. Criminal appeal was also there.
Yes.
What happened to the criminal appeal?
was, Lordship,
Dismiss. Give me, comma. Peruse the connected record. It is seen that the by the aforesaid appellate order dated 17/7/2023, passed in criminal appeal number 02 of 2021, the judgment and order dated 4/1/2021, passed by the learned CJM Dhubri in GR case number 704 of 2021 was upheld. Therefore, for the purpose of the stay as granted, the it is corrected that it is corrected to the following effect. Inverted comma. The applicant shall remain on previous bail in connection with the impugned judgment and order dated 4/1/2021, passed by the learned Chief Judicial Magistrate Dhubri in GR case number 704 of 2021. Full stop. Accordingly, the present application, the order dated so and so, earlier order dated,
post 25.
order dated 25/8/2023, passed in criminal,
IA number
IA number
749.
IA number, let us not commit a mistake. IA criminal 749 of 2023 is corrected to the above. IA stands this point. At a criminal division, main case.
I'm on behalf of my lord, Mr. A.K. Kumar, his own name, for the respondent.
None appears for a petitioner on call. The present application is filed for impleading the present, the IA is filed. This IA is filed for impleading the present incumbent holding the post of Secretary, Government of Assam, Water Resource Department as contempt number 2. However, this court, under its order dated 21/10/2019, adjourned the matter for period of 4 years, as there was nothing on record to show that the aforesaid incumbent was made aware of the order passed by this court. Full stop. As none appears for the petitioner on call, in the interest of justice, matter stands adjourned and be listed after 6 weeks.
Lordship, service has been not completed.
How will it be completed if you do not take steps?
They are newly implemented, Your Honor.
If you do not take steps, how it will be completed?
Your Honor,
Which respondent you need to take steps? Yes.
wait, Lord.
Yes.
Sorry, my Lord. Newly implemented respondent number 9 and 12. So the service is not complete upon them.
Have you taken steps?
Yes, my Lord. The matter came up before Lavadima House many a time.
Then
But address could not be found out. If the respondent side help us in finding provide us with the address, my Lord, because on the earlier occasion they provide us the name of the 5, my Lord, respondents which would be completed as
who are these respondents?
they are, my Lord, they have been selected candidates,
Give a paper publication.
my Lord.
The learned counsel for the petitioner submits that though a direction has been issued by the Lajima Court on 29/9/2023 to take steps upon respondent number 9 and 12 by registered post within 7 days from the aforesaid order. However, such steps could not be taken up for one of detailed address of respondent number 9 and 12. Yes, who is the which one is the department?
APDCL method.
Where is APDCL? Let us take a chance instead of going for paper public. It will cost you as it is the case of the petitioner that respondent number 9 and 12 has been selected, appointed and now serving under the respondent APDCL, the standing counsel for the respondent may assist this court and the petitioner in obtaining the proper address of those persons. However, none appears for the APDCL on call. Accordingly, matter stands adjourned and be listed after the case. We'll see you have a contact and they may collect it if it.
Publish. If you
So operative question page 37.
Yes, you are appearing.
Yes,
Yes.
I have page 37 Lordship. Only column number 5 Lordship. Others are complied. 37. All
Okay.
payments due
Page 37.
37. Direction Lordship.
Related papers relating to the regulation of overstay of leave. Isn't it?
Yes, already others are complied only regarding column number 5 Lordship. All payments due to the petitioner shall be released thereafter within a period of
The column, I am not getting any column.
my contempt petition.
Contempt petition page 37 is the last part of the judgment.
Yes, Lordship. Last 5 Lordship. Serial number 5.
Paragraph 5.
These are the Lordship, paragraph 30, page 36, paragraph 30, direction Lordship.
Direction.
Yes, Lordship. Then last one is 5. Serial number
All
5.
payments due to petitioner shall be released
Thereafter within a period of 4 weeks. My resignation was accepted, Lordship, in the year 2019, Lordship. After Lordship, payments are not paid, Lordship. I have received instruction. My Lord, I may be either allowed to file that affidavit that instruction or maybe the senior inspector whether she is agree with that, my Lord. I have received the instruction regarding this
What is
payment.
your instruction?
Regarding my Lord, in the page 76 of it, there affidavit in reply, my Lord. There are 17. One is my Lord gratuity. 76. These are my entitlement. That is their entitlement.
Paragraph page?
76, running page 76, page, paragraph 17.
No running page is there.
Affidavit in reply filed by me, Lord.
Paragraphs, okay. 76. Yes.
Paragraph 17, these are my entitlement.
Okay. What is your instruction?
My Lord, regarding 1, 2, 3, 4, my Lord, they have sent to the higher authorities for approval, my Lord. And regarding 5, there is some objection in regarding 5, Roman 5, my Lord. My Lord, in this regard, the office has advanced drawn rupees 4 to 40.
To file an affidavit.
Yes,
then.
my Lord, I have
Okay.
letter.
Okay. The learned counsel representing respondent number 1 and 2 submits that she has received instruction and would like to file an affidavit. Accordingly, matter stands adjourned and be listed after vacation.
Date may be fixed. Yes, sir.
Date we can fix, no problem, but whether she'll be able to file.
Yes, he will file. Immediately after vacation, I'll file.
Okay, give a date second week.
My Lord, 12 January.
Yeah.
At any other date, 12 January. 19, 8.
8 of them.
Apply. Master.
Yes.
There's an order from the law jama to pay, okay, by order date 15/12/2023, my lord. My lord, after my lord, the earlier step, the second part address is not correct. And they have now, my lord, after filing affidavit by government, we have get the proper address. So, my lord, court
Okay,
maybe allows to
the learned counsel
amend
for the petitioner submits that could now collect the proper address of the for the respondent number
my lord,
6. Respondent number 6. Accordingly, he prays that he may be granted a week's time to file.
amended for settlement, I may allow.
Okay. No, that cannot be. Okay. You need to take steps only.
No matter this by the for filing interlocutory application if to apply. I think that that's in view of the above petitioner may take steps amending the court title reflective.
The problem is that when you change it, there must be an statement that this is the correct address. This should be on the vote.
Affidavit is there, madam. There affidavit, there is a document.
No, understand.
Affidavit.
You file an application.
Right.
It should. You make some addresses corrections of address, little bit, whole addresses. Corrected, and accordingly he prays that he may be granted 1 week time. We are giving you 1 week time, a week's time to file an 2 weeks time to file an application for correction of the cost title and the address of the prayer is allowed. Please take over.
Application is filed for a without to declare.
IA file for
But for leave for declaring the result matter. Or the assistant engineer can
May I please the matter can you pass for some time?
or to
for this matter, that engineer.
Lord.
already that they have that notification has been issued. They have entered into an agreement. Everything has been done. They are
He want his senior. And appears for the petitioner and for list of the vacancies. Yes, Mr. Nayak.
Not to be the case of where.
You were supposed to
You were-
learn some
Yes,
judgment.
I have received the report.
Yes.
Lordship, that speaking order of
Where was the speaking order?
In order is that page. It's the file lordship where the
Okay. Now I recall.
that is processed in this file.
Which one? Which plague is that?
Lordship would like to see the first page of it.
First plague?
Yes. Lordship, it is even prior to the passing of the judgment by this honorable court, Lordship. This matter was under process.
Okay.
Then Lordship would like to come to page 6. Lordship.
Page 6.
It's a note to the Commissioner and Secretary, Lordship.
Okay. Okay.
Lordship, if Lordship allows me to read, Lordship. Note prepaid and above. 26 numbers of undergraduate senior administrative assistant along with 9 numbers of graduate senior AA have been qualified for the post of superintendent by completing and passing the Group B training since 2019 to 2021. Already a cabinet memo was placed before the Honorable CM for approval for placing the matter in the Honorable Cabinet regarding the relaxation of the provision of educational qualification for the 26 numbers of undergraduate income. And Lordship will see in the next page, Lordship, page 8.
Just a minute. Page 8.
Yes, sir.
Okay.
Lordship will find one writing in red ink, Lordship. High Court order is it 29/9/2021 again.
Okay. That order on the basis of which you have taken.
Is taking order of us. Lordship will see the notes, Lordship. Order of the Honorable Chief Secretary has prevailed. In the meantime, Honorable Guwahati High Court has issued an interim order dated 29/9/2021 against case number so and so. Order copy downloaded from the website is placed flag tag for appraisal of Chief Secretary. Next, note your Lordship will see.
Page 9.
Same page, Lordship. Page 8. Last paragraph, Lordship. As there is a cabinet meeting scheduled for tomorrow, the link file setting, this is not maybe skip, Lordship. Lordship will come to page 9.
Page 9. Page 9.
Page 9, Lordship. Same note, Lordship. Lordship will see the first, second, third, fourth, fifth para.
In between.
In between, Lordship. To sort. In between, no, Lordship. It's sort from to sort.
To sort out.
To sort out the issue of the representation seeking relaxation of educational qualification of the senior AA, a cabinet member. Same these are under process.
Okay.
Then page 15, Lordship.
Yes.
This is a note to the additional secretary, Lordship. I'm not reading the entire page, Lordship. 6th paragraph, Lordship. The Secretariat Administration Department. The Secretariat Administration Department has replaced the earlier service rule by the Assam Secretariat Service Rule 2019 to change over to the requirements of the new generation. Accordingly, in the provision of filling up of the post of superintendent, possession of graduate degree has been inserted as a mandatory criteria, along with the other criteria of having minimum 5 years qualifying service as senior A and passing of Group B training. So this is the note given, Lord. So this is the requirement of the new generation. On the keeping in mind that, Lordship, the new rule was implemented and the earlier rule was repealed. Last paragraph, Lordship will say, therefore, we may place the matter before the Honorable CM again for kind approval towards placing the matter before the Honorable Cabinet. The next page, Lordship will see, page 16.
Page.
Page 16.
Yes.
Lordship will see the note down below at the bottom, Lordship. Discuss. Please put up a self-contained note. Lordship will find that note at page 22 of the record.
Page 22.
This is note sheet, Lordship, in the next record. Not in the note page, Lordship, record. Record, Lordship, in the next page. One flag is there, self-contained note.
Self-contained note.
Yeah.
Okay.
That copy is not right there. And
Now
Lordship
what?
will again come back to the note page, Lordship, page 17.
Okay. Page 70.
Page 17, Lordship. First note, order of the additional secretary at prepaid. Accordingly, a self-contained note is
Okay,
placed below.
that we have already read.
Lordship. Same Lordship.
Now
Lordship will come to the next page, page 18.
page 80.
80.
Yes.
The Assam Secretariat Service Bill 1963 has been repealed.
Page 18 started Chief Secretary, your
Yeah.
direction. Okay.
Yeah.
Self-contained. As per the, okay. Assam Secretary. Yes.
Assam Secretariat Service Bill 1963 has been repealed with the Assam Secretariat Service Bill 2019 and officially published in the Gazette on 13/6/2019 with effect from that date. The next paragraph has been struck off. Next, Lordship, as per the new rules, the minimum educational qualification required for the post of superintendent, group B training, superintendent, B, superintendent graduation of graduation degree. This is not
So this officially with effect from
Next,
that
as the petitioners do not possess the required qualification, we may dispose of their petition.
we may reject.
We may reject. We may dispose of.
No. Here dispose of is deleted and here
Page 18, Lord.
18.
As the petitioners do not
As
possess
the
the
petitioner do
required
not possess the required
we may
qualification,
dispose of
comma,
their petition.
we may dispose is cut, then reject by pen. Their petitions due to lack of merit.
Yes, due to lack of merit.
After that, the promotion case of eligible candidates may be considered as per High Court.
So this is the first reason given now.
Okay.
Next page, your Lordship will see page 18. It's a type copy, Lordship. I was reading the handwritten, now the type copy.
Page
18 now.
page 18 type copy.
Yes, okay. 2 page 18 are there, Lordship.
218 pages.
First one is written, handwritten. Second one is yes.
Okay.
Lordship later is second page.
Uh-huh.
In the second page, Lordship will see the last paragraph. First paragraph, Lordship has already seen. As the petitioners do not possess the required qualifications, we may reject their petition due to lack of merit. After that, the promotion case of eligible candidates may be. So this is the first reason now.
Okay.
Then Lordship will see page 19.
Page 19.
In the same page, Lordship, page 18. Please put up, this is the
with
signature
speaking order draft.
For preparation of a draft order law. It's the signature by the Chief Secretary law. Next page, page 19. Accordingly, draft speaking order placed at flag M. So the speaking order was ultimately passed.
Based on this reason.
Lordship, page 20, Lordship will see first line,
Hmm.
speaking order,
Hmm.
by
As
serial
per
number.
verbal order,
issued.
Chief Secretary Assam,
So
date
that
of
is-
previously meeting is fixed on 30th.
That is the speaking order, page 100. Now, it is not the ground of my learned friend that this order contains no reason. This order, no reason has been given in this order. If Lordship sees the speaking order, Lordship,
Hmm.
Lordship will see at page 101.
101 of the file
Yes, sir.
or record,
No, read petition.
read petition. So now we can,
Yes, record.
for the time being, we are
Lord.
100.
101 now. Lordship, one paragraph will say Lordship, fifth paragraph, Lordship, whereas in 2019, page 101,
Hmm.
whereas in 2019, the
Hmm.
Assam Secretariat Service Rule 1963 has been repealed, with the Assam Secretariat Service Rule 2019, which has been notified in the Assam Gazette on 13/6/2019 and came into force with effect from the official publication of the rule in Assam Gazette. Therefore, the affected incumbent serving as senior AA without graduation degree submitted petitions for relaxation for relaxing their educational qualification and consider them for promotion to the cadre of superintendent. Then Lordship will see the last paragraph of that page, Lordship.
There is no candidate.
Whereas no candidate without required educational qualification, that is graduation, has been considered for promotion to the post of superintendent after amendment of the state rules. Then Lordship will see the paragraph 3 of the
Although the provision. Hmm. Although.
although
Starts with
although the provision of Rule 16 stipulates that the Gov has the power to relax the provisions of this rule, it is an exception rather than the rule. If such relaxation was to be given in each and every case, the very purpose of enacting the new rules shall be defeated. Accordingly, the provisions of Rule 16 are to be used cautiously and not for all the time. The two specific grounds are there. One is after the coming into effect of the new rule, no candidate not having the graduation degree has been considered for promotion to the post of superintendent. And second ground is it is just an exception. It cannot be applied as a rule for everyone. So these two grounds are specifically mentioned. So it cannot be said that speaking order is devoid of any reason for. So as I have submitted, petitioner has not taken the it is just a query from your lordship. One judgment I would like to place.
Yes.
Whether reasons is necessary for the administrative authority to give reason while passing a speaking order. I am relying on lordship paragraph 2, 4, 8, 9, and 10. Paragraph 2, Lordship. This appeal is directed against the order of the Central
Yes,
Administrative Delhi questioning the order of the Ministry of Commerce dated January 6, 1986, rejecting the respondent's representation against the adverse. Then Lordship will come to paragraph 4. The tribunal held that it was a basic principle of natural justice of every quasi-judicial process that orders should contain reason. Arriving at a just decision is the aim of both quasi-judicial as well as administrative inquiry. An unjust decision is an administrative in an administrative inquiry may have more far-reaching effect than in a quasi-judicial inquiry. Therefore, it was necessary that in rejecting the representation against an adverse entry, reasons must be stated, and in the absence of reasons, the order would arbitrary and liable to be quashed. Placing reliance on a number of decisions of High Court, the tribunal held that a bold communication rejecting the representation made against the adverse entries does not meet the requirements of law. The tribunal further held that in the absence of reason, it would follow that competent authority rejected the representation without applying its mind to the grounds raised in the representation. Then Lordship will come to paragraph 8, page 44. The question is whether principle of natural justice, page 44. The question is whether principle of natural justice require an administrative authority to record reason. Generally, principles of natural justice require that opportunity of hearing should be given to the person against whom an administrative order is passed. The application of principles of natural justice and it will depend upon the nature of the rights involved. Having regard to the setting and context of the statutory provision, where a vested right is adversely affected by an administrative order or where civil consequences ensue, principles of natural justice apply even in the statutory provisions, even if the statutory provisions do not make any express provisions for the same, and the persons concerned must be afforded opportunity of hearing before the order is passed. But principles of natural justice do not require the administrative authority to record reasons for the decisions, as there is no general rule that reasons must be given for administrative decisions. Order of an administrative authority, which is no statutory or implied duty to state reasons for the ground of its decision, is not rendered illegal merely on account of absence of reason. It has never been a principle of natural justice that reason should be given for decision. Then next line of it, though the principles of natural justice do not require reasons for decision, there is necessity for giving reason in view of the expanding law of judicial review to enable the citizens to discover the reasoning behind the decision. Right to reason isn't the indisputable part of sound system of judicial review. Under our Constitution, an administrative decision is subject to judicial review if it affects the rights of the citizen. It is therefore desirable that reasons should be stated. 9. There are, however, many areas of administrative activity where no reasons are recorded or communicated. If such a decision is challenged before the court for judicial review, the reasons for decisions may be placed before the court. The superior authority, while considering the representation of a government servant against adverse remarks, is not required by law to act judicially. It is under
Finally, is that the reasons contained in the file enable the competent authority to formulate this opinion. If the order as communicated to the government servant rejecting the represent does not contain any reason, the order cannot be held to be based only on in law.
law.
If such order is challenged in court of law, it is always upon court competent to place the reasons before the court which may have led to rejection of the representation. It is always upon court authority to produce evidence. So therefore, that's why we have asked you.
One last
because-
one last paragraph I would like to read, Lordship. Paragraph 10. Paragraph 10.
In absence of any statutory rule or statutory instruction requiring competing authority to record reasons in rejecting representative, I've read it.
So that is, here Lordship will see 3-4 things, Lordship. First, there is no statutory obligation for the authority to give reasons, Lordship, while passing a speaking order, especially in this case. Secondly, Lordship, even if reason is not given, so it is not my case, Lordship. In my humble submission, two
Reason is
reasons are
given.
there. Even though reasons are not given, that would not have prejudiced the petitioner, Lordship, as no statutory
Right is there.
that accrue in favor of the petitioner. that
Because
has
he is not having the quality.
So far as in terms of the rule, Lordship, he has no right to claim promotion to the next higher court. So these are the basic two reasons. So far as the limited adjudication, Lordship,
Adjudication
whether-
is limited. We cannot say that no, he is qualified or his qualification should be relaxed.
No.
That it is for clear, we are not here to see to an appellate. We will have to see whether in the context of the rule and your power, that power has been properly exercised. Your case is that power has been properly exercised, his representation was considered, application of mine to deer, and the authority has kept a conclusion that first, after 2019, rule is
New
new rule has come. In terms of new rule,
requirement is graduation degree.
requirement is graduation. So a principle has been taken that this qualification we will not relax. So therefore, there is no question of relaxation.
That will be fine. And otherwise, Lordship, if he is agree with the provisions of the rule law, that rule is already under challenge in the division. He may take recourse to that.
Yes.
That
Yes.
is
What is your reply?
My lord, since the rule, my lord, itself given the scope for promotion, my lord, by relaxing the provision. Particular
Let us see the rule first.
lords. Since in earlier occasion also in different court has said that the rule has not been challenged, since there is a provision itself. The question of challenging rules.
No, no, your case is that
Yes.
here is a provision for relaxation, and
Exactly.
that power has not been properly exercised.
Exactly.
That is your case.
Yes. And my lord, since on the same similar line, my lord, this honorable court held several decisions, my lord, and where the promotion has been given to the person, my lord. The same person, same footing, my lord. And I will rely that the decisions of the court. Lordship will go by the notification, the rule, my lord. And we are admitting we are not the gazette person. 16 Lordship. Rule 16. Where the government is satisfied that the operation of any of these rules may cause undue hardship in any particular case, it may dispense with or relax that rule to such extent and subject to such conditions as it may consider necessary for dealing with the case in a just and equitable manner. In other cases, already they have considered. And in my case, they are not considering, though they have the same qualification, my lord, higher tendency, but they have been promoted. They need the graduation, but they have already relaxed the rules for that time. I have the documents, my lord. I will show for Lord. This discrimination, Article 14 and 16, Lord, provided that the case of any person shall not be dealt with in any manner less favorable to him than that of provided by any of these rules. But since the rule has provided, and in other cases they have already given the promotion who have the high tendency, my lord, and only in the case of the petitioner, why they are discriminating, why they are depriving, I do not know, my lord, what they have to say, my lord. But I'm not saying I'm graduate. Had there been the graduate, today I would not have been before a lot. And since this person now they are going to be retired, and some of persons have been retired, how they will acquire this graduate degree? Not possible. And since, my lord, both them, I'm not saying had I been the newcomer, my lord, certainly I would not have come before long. Because for newcomer, for new generation, my lord, he has said already, for new generation, this graduation is necessary. Yes. But for those persons who have rendered already 30 years service, 27 years of service, my lord, now they are going to be retired. But this discrimination, my lord, and this at least for one-time measure, the honorable court, my lord, in different judgment has said that one-time measure has to be once a new rule has come, and he doesn't have the qualification. And for that, since the rule has provided to relax, if that provision is there, then certainly the government is duty bound to consider their cases, considering their undue hardship. And had there been the sufficient age, matter is different. They can prosecute their degree, all these things. Now they are at the part of retirement. There some of the persons have been retired, and some of the persons are going to be retired. And it's totally blocked to them, my lord, at the last stage, my lord. That is why, my lord, I have come before Lordship, my lord. And since in earlier occasion also this honorable court has repeatedly asked the counsel for the opposite party, my lord, that since the impugned order, fixed order has been passed, it's not as per the provision, as per the rule 16. They had to consider it. And that case, my lord, knowing fully well, my lord, they are depriving, they are at least one-time measure has to be followed. That has not been done. The Honorable, our High Court has said, my lord, even for double promotion, it is given because of not having the B.Ed degree, my lord, he was not promoted. In one case, letter that is also I have enclosed in IA, my lord, in the case, my lord. I have already closed, and I would like to, just read out the judgment, my lord. Place the judgment.
Which judgment?
My lord, ma'am.
Give.
First, I would like to rely 2021 TLP 108, my lord.
There are some judgments here packed.
Yes.
There are some judgments. I think one is Monikanta Sinha. What is Monikanta? Then 2021 GLT 108.
Yes.
What is the parameter here?
Let Susmita Sutradhar,
Susmita Sutra.
Yes.
Paragraph?
Yes. Lordship will find para 14, 15, 16, madam. On the other hand, because of mere possession of beard, many of those who were junior to the petitioner will overnight become senior to her, even without discharging the duties and holding the post of deputy director. Thus, this one-time exercise will have to the effect of adversely affecting the interest of the petitioner and can be said to be arbitrary and discriminatory as far as the petitioner is concerned. In the light of the above observations, court expects that the state authority would take necessary steps for relaxing the aforesaid requirement of possession of PhD degree by the petitioner and also in respect of other employees mentioned above, so that this one-time relaxation measure undertaken by the authorities comes to a closure without any disillusionment on the part of any of the remaining existing incumbents. Though the aforesaid two persons, namely Srimati Meena Kumari Bora and Dr. Sutiful Borua, are not before the court, considering the nature of the case and similarity of the situation in which they are placed with the present petitioner. This court, without their appearance, this court has made observation that the authority will also relax the qualification in respect of this also for grant of double promotion. Accordingly, under the facts and circumstances as discussed above, even though the state authority had rejected the case for relaxation of the requirement of possession of PhD degree by the petitioner, the state authority will reconsider the matter and take a fresh decision for relaxing the requirement of PhD degree, so that the petitioner and aforesaid two persons, namely so and so, can also be given double promotion as given to others. The state government will thereafter issue necessary consequential order for double promotion to the of the petitioner to the post of additional director and the other two persons named so and so higher post by giving similar benefit as given to other private respondents. The writ petition was according earlier in the recommendation made by the departmental selection committee held on as regards the private respondent and the consequent promotion so and so of the private shall be given effect so and so. My lord, these are because he didn't have the PhD degree, my lord, for promotion to the deputy director, and subsequently some of the persons similarly they have been additional directors. So double promotion has been made. And accordingly, this honorable court, considering the one-time measure, my lord, since they are going to be retired, and as a whole, my lord, this honorable court considered. And secondly, my lord, this 2022 CCLT 59.5 is a division bench of this Guwahati High Court at Mizoram, state of Mizoram.
Joshua,
Yes, Dunung Thara.
Churungthar.
But here, Parasic plot will find. Though in the writ petition, the petitioner has challenged the view virus of the part of the rule insofar as the qualification prescribed for promotion to the post of Deputy Director, Science Promotion Wing is concerned. Indicated above, the learned counsel for the petitioner has, during the course of hearing, submitted that he is not urging the same. Instead, he has referred to Rule 8 of the 2013 rules in support of his contention in respect of the petitioner's alternative prayer. Yes. So ultimately, my lord, this honorable court considered para 14 notes. Para 14, my lord, upon consideration of the aforesaid facts and circumstances, more particular the fact that petitioner has been serving in the post of science consultant for a period of more than 9 years. We are of the considered opinion that as the 2013 rules itself has provided for the power of relaxation of any of the provisions of the 2013 rules with respect to any class or category of person, the respondent should consider the case of the petitioner in terms of the provisions of Rule 8 quoted above by taking into account all the relevant factors into consideration for the purpose of further consideration of the case for promotion to the post of Deputy Director Science and it is accordingly directed. The required exercise in terms of the order shall be carried out and completed as expeditious as possible, preferably within a period of 3 months from the date of furnishing a certified copy of the court. It is, however, made clear that this court has not observed anything as regards the merit of the claim of the petitioner as regards to the relaxation of 7 except the extent indicated above. This is the fact. Now, there is also a Supreme Court judgment, 1998 for SEC 17.
1990 to 1997.
And 97 is
RM Puchi Sandeep Kumar Sharma.
yes, since 97 is referred in 1998, my lord.
Okay.
Here, my lord,
1990 it is Ashok Kumar Utpal.
Lord Ashok Kumar. Here, my lord, in para 25, my lord, 25, 26, 27, my lord, and 29, 30. We 25, we are therefore clearly of the opinion that it was a case in which the government had not acted arbitrarily or capriciously, but had proceeded to relax the rules to obviate genuine hardship caused to a class or employees, namely the appellant, and directed their promotion in relaxation of the rules. Power to relax the recruitment rules or any other rule made by the state government under Rule Article 309 of the Constitution, of which the corresponding provision is contained in Section 124 of the Constitution of each Dominion Constitution, is conferred upon the government to meet any emergent situation where injustice might have been caused or is likely to be caused to any individual employee or class of employee, or where the working of the rule might have become impossible. Under service jurisprudence as also administrative law, such a power has necessarily to be conceded to the employer, particularly the state government or the central government, who have deal with the hundreds of employees working under them in different departments, including the central or state secretary. I mean the state secretary in state of Maharashtra. So and so, hell is under. That is the power to relax the conditions of the rules to avoid undue hardship in any case or class of cases cannot now be gainsaid. It would be therefore futile for the respondents to make any grievance. In Jesse Yadav, my lord, that is 28 para, the relaxation of rules may be to the extent the state government may consider necessary for dealing with a particular situation in a just and equitable manner, my lord. That part is there, one. The scope of rule is wide enough to confer power on the state government to relax the requirement rules in respect of an individual or class of individuals to the extent it may consider necessary for dealing with the case in a just and equitable manner. The power of relaxation is generally contained in the rules with a view to mitigate undue hardship or to meet a particular situation. Many a time strict application of service rules create a situation where a particular individual or a set of individuals may suffer undue hardship. And further, there may be a situation where requisite qualified persons may not be available for
Sir,
appointment to
Shetty,
the
just one query. Yes, it is well settled. That rule, power to relax rule is given to do certain exceptional thing, rehearse the rule. That is the power to relax. The satisfaction, this provision is given in a situation where there are hardship, undue hardship to a class of people, class of employees. They can have a decision as a whole on those class of people. Here there is 26 numbers, isn't it? Or they can, in certain cases, they can have a individual application. If this person is having this, okay, let us relax the rule. He is having undue hardship. Just an equitable consideration would be to consider to give him the benefit. Now, other part is that such benefit should not harm the others, and benefit giving to a somebody should not again be a hardship to others. Okay, this is the principle of law, no doubt about this. Here they took a view that, see, we have amended the rule, so we will not allow non-graduates to hold the promotion. That is their reason. So they may not say in so many terms that how it will be hardship, how it is unequitable. Suppose they have taken a principle stand that no, we will not relax this qualification. Can this court sit over and say that no, it is indeed a hardship, therefore you relax? This is one aspect. Other aspect, Mr. Nayak will address, that from the record, you say that even after the notification, it's your own record. After the gazette notification, you have given relaxation. No, in the record.
Yes.
In the record, you say that even after notification, we have given. According to you, those posts were or those vacancies were prior to the rule.
Their consideration was started prior to that.
Their
Suppose on 4.
Okay, their consideration started prior to the rule. So therefore, you cannot say that there is a discrimination what he is arguing.
But that point, my lord, I must say, those persons were not qualified when the process was taken prior to the rule. They were not qualified. They did not pass the B group training.
No.
Without passing B group training, they cannot be qualified. And persons who have passed the
No,
rule,
that aspect we may not go into because whether they were qualified, they are not before us. They are not before us.
no,
These persons are not before us because we will not go whether they are having B or not. That part will not go. Their stand is will deliberate on it. Their stand is that okay, their considerations were prior to the amendment of the rule. Their cases were placed or their cases for promotion were initiated prior to the amendment of the rule. As that was continuing, so we considered their case as a different class of people. Anyway, that is their argument.
that was the deliberation in earlier occasion also. And only the rule came in 13th of June 2000. And firstly, they promoted the candidate on 24th of immediately after 7 days or they promoted some of the part, 30-40% by relying the old rule.
That is B training, something B
group training.
B group training, they will have to qualify.
suppose for the timing I'm forgetting this 24/6 2019 promotion. They have also made the promotion in 31st of December 2019 after about 8 months. Whereas the promotion to be made once he or she
What
has
is the cabinet decision finally? Anything on record?
Reflected in the fact
Not reflected.
some other filing.
and that part, my lord, the honorable court earlier occasion took up the seriously. Since this continuation cannot be, because they passed the B group training only in the month of July. If they pass the B group training in July and and 3-4 candidate in November, they passed the B group training in November, and in December they got promotion. And how can it be the continuation from? That cannot be. That's totally. I'm not
You have
saying.
filed reply.
Yes.
Okay.
And my lord, in the affidavit also, they have categorically stated that for the this under secretary, my lord, since they did not have the qualification, my lord, and their qualification has been relaxed by virtue of this affidavit, and in my reply also, I have given categorically that they have relaxed those parts. Even the required qualification was not there for under secretary, but that has been, they have already relaxed. And if such that fact has been stated by their in their affidavit itself also, they have admitted. And that part also I have replied in the reply also. And if that the action of the respondent is continuing, he can choose. Let somebody they like it, they have given the promotion by taking the 1963 rules in 2019 December, and some of the under secretary they did not have the requisite qualification. They have been relaxed, and accordingly approval was made, and accordingly they have been promoted. And other, my lord, other recently, my lord, the secretary, the stenographer in the this service rules 1963 of itself, where they were working and the requirement was degree for promotion. Within short time, this 23, 22, they have relaxed and they have promoted. I have the document. And if that being the position, madam, everyone is promoting by relaxing their qualifications, madam, where is the impediment for this petitioner to get the promotion, madam, like others? And since this honorable court also held that as because the petitioner did not have the requisite qualification doesn't mean that one-time measure has not been. The one-time measure has to be followed. And my lord, this rule is for young generation, new generation, my lord. That is, I'm not denying. And secondly, my lord, since the petitioners are at the verge of retirement, they are already retired. Some of the persons, where they will go, and their right has been now to consider for promotion, my lord, that has been stopped. As because they do not have the abruptly somebody has come, the rule has come, and at the time of return, now I've been blocked from. But provision is there. And my lord, since in earlier occasion also this honorable court has held that since the rule has not been challenged, but under the provisions of rule, it has been raised before the honorable court. That cannot be a query or question to raise before this honorable court. That was
You have entered into service as what?
as my lord, a grade for employment.
Then you LDA.
Grade for yes, LDA.
Now it is a UTA post. Superintendent.
UT. So my lord, only my lord, since now I have come to know, my lord, similar to this petitioner, my lord, they have already been promoted as under secretary, who were undergraduate, and now they are my friends are under secretary, and still I'm in the post of UTA, my lord. That is the only discrimination, my lord, and this.
What is the qualification from superintendent to under secretary?
Now earlier, my lord, this recently, and he has to be eligible for 5 years experience, and B group training has.
I think they are having that now. Uh,
Even this new
In a second promotion, there is no relaxation.
in the second promotion, my lord, there was no relaxation, but
But they are all in them qualified. They are qualified.
no, my lord, 31st.
Qualification is not just promotion superintendent to under secretary.
No, only for the
That is a
experience,
different
seniority and
service.
experience.
Now they are
Seniority.
regulated as senior administrative assistant. They are regulated by the Assam Secretariat Subordinate Service Code. And the promotion they are claiming lordship is regulated by
And-
another service called Assam Secretariat Service Code.
This
But that is a different service code.
That-
That this is
No, these are not relevant here because
Yes.
we are on the
Yes.
power of relaxation
Yes.
and exercise. We are basically on exercise of power.
yes, and that there should not be any discrimination. That's the point I am raising. There should not be any deprivation.
Okay, just we'll record some facts for the time being.
Sure.
We'll continue in the new year instead of keeping it CF. Just we'll record the submissions, then finalization after.
as my learned friend is asking to merit of the case.
Mm.
They thought that would also like
No. Merit. That's what I have said. That who has been refused, who was having qualification. Merit we cannot go. Here the issue is where the power of relaxation has been exercised in terms of the act. We cannot give because the terms of the act is equitable consideration, just consideration. And it is a discretionary power. If the discretionary power is
on that
exercised
on that point, like
Ah.
I would like
if it is exercised is exercised properly, the reason may not be justiciable. Reason may not be just. Suppose an employer decides that higher qualification is required, and therefore they will not relax the rule insofar relating to this to that. Can we impose that no? Since you have done in some other cases, do it. This is one aspect of the matter. Other aspect of the matter, we cannot enter into the merit and say that no, this is a fit case for relax. What we can see is whether that application was proper or not. The decision-making process. Okay?
in fact, Lordship, one very recent judgment, Lordship, 1st of August 2023, Lordship.
What is
Wherein,
this?
Lordship, we granted relaxation to some employees, Lordship.
Hmm.
That was interfered by this.
Because that might be another aspect because
Same service,
because
same department.
because the other party will come and say that you have
That is the
No, the actual part is different.
no,
Let-
not.
let-
I'm not going on that factual part, but that can be another ground. They might not have written it, but there might be another ground because it should not affect. It should be a balancing act. Anyway, we'll deal with everything.
Yes.
Minds are open. Just we'll record the facts because otherwise
Now,
last day of the court may not be possible to complete this. Heard Mr. P. Setri, learned counsel for the petitioner, also heard Mr. P. Nayak, learned counsel for the respondents. Though multiple prayers are made in this writ petition, however, Mr. Setri, learned counsel for the petitioner, has submitted that he will confine his argument only confine his argument relating to prayers A, C, and D. Isn't it? The basic salience in this writ petition is an order dated 30/10/2021 passed by the Chief Secretary to the Government of Assam pursuant to passed pursuant to an order of this court that the orders of this court dated 22/9/2021, 6/10/2021, and 7/10/2021 passed in WPC 5136/2021, WPC 5376/2021, and WPC 5501 of 2021, respectively. The aforesaid writ petitions were preferred by the present petitioners and their case for consideration for the next higher consideration for promotion to the next higher grade to the next higher grade was directed in terms of power of relaxation of rule under Rule 19, isn't it? Rule 16 of Assam Secretariat Service Rules 19, Rule 2019. Full stop. Within bracket, fair enough, after referred to as Rule 19. The Chief Secretary, by the impugned order dated 30/10/2021, rejected a prayer of the petitioners for relaxation of educational qualification, basically on the ground that such relaxation of educational qualification cannot be granted in each and every case, inasmuch as such action will defeat the very purpose of enacting the new rules, by enacting the new rules 2019 by repealing the earlier rule, that is Assam Secretariat Service Rule 1963, which was holding 1963. Full stop. Pursuant to this court's order dated 14/12/2023, the 14/12/2023, Mr. Nayak Learned Counsel has produced the record pertaining to the consideration of the case of the petitioner under Rule 16 of the Rule 19. Full stop. From the pleading of the petitioner made in the writ petition, as well as from the record, the following facts are discernible. Full stop. Even prior to 1, 2, 3, 3, even prior to approaching this court by the petitioners, a memorandum was submitted by the Assam Secretariat Service Association, including some individual employees, for consideration for relaxation of educational qualification for the next higher post. Full stop. Under Rule 1963, what was that your position? LDA, or what is the junior assistant?
Senior administrative.
No. The feeder cadre.
No,
Feeder cadre?
grade 4. Grade 3.
Feeder cadre of the promotion they are seeking.
Senior administrative.
They are senior
Yeah.
administrative.
Next promotion will be superintendent.
Because under Rule 1963 also.
Senior administrative assistant 1963 and now Lordship Superintendent 2019.
In under 1963, what was their designation before promotion? That
Senior administrative.
same, na? Both the rules same.
Yeah.
Okay. Assam Secretary Service Association. And under the Rule 1963, the promotion from the educational qualification for promotion from the post of junior administrative assistant to the post of superintendent is senior
Administrative
assistant
to
to superintendent is
qualification
63.
and Rule 9.
1963. What is the qualification?
There was no qualification.
What was
Only
the
high
what
tendency.
was the requirement for promotion?
Only high tendency and the 5 years.
Give us the rule. 263 rule. No, you have said there are some group B and all.
Group is for
Group is
group
the
A with, group A
eligibility.
for
Give me the rule. Give it 1963.
63.
Because your whole case is that the rule holding the field was favorable to us. The new rule has taken our right for promotion. Therefore, you have challenged it. Till such challenge is made, you say that relax. You have a power to relax. I think this is the case.
Yeah.
Yes.
Rule 8.
Rule 8.
5 years as UPA plus
Okay.
confirmation.
People. To the post of superintendent. The required qualification is at least 5 years of service as upper division assistant. You are holding the post of upper division.
No, that nomenclature has been changed.
No, that is why I'm saying in 1963.
No,
It
or
was
in subsequent notification, Lordship will find it as senior administrative. It is the original.
okay. Senior administrative assistant slash upper division assistant. So the senior assistant, upper division assistant. At least 5 years service as upper division assistant slash senior administrative assistant and confirm in that cadre. The confirmation in cadre in UDA slash senior administrative assistants SAA, senior administrative assistant requires, where is that? B, training B.
Group C training, one notification is there of personal department.
Requires.
Earlier it was not mentioned. Lordship will find one paragraph as confirmation.
Okay, not necessary. Let it be there. That is not relevant for. That is the
confirmation Lordship group is.
okay. That is not necessary for the time being. Confirmation that we have seen. Okay, and confirm in that we have given. Okay. Such rule was repealed by another rule, namely Assam Secretariat Administration, Assam Secretariat Service Rules 2019. In terms of 2000 Rule 2019, the qualification or promotion to the post of superintendent has been modified, and it is prescribed that it should be 5 years of continuous service as administrative assistant and the candidate must have passed Group B training or equivalent as prescribed by government. Proviso to Rule 5, which prescribes the qualification promotion of Rule 2019, mandates that such a candidate must possess a graduate degree in any stream as academic qualification from any recognized university. Full stop. Rule 16 of the Rule 2019 further provides that when a government is satisfied that operation of any of these rules may cause undue hardship in any particular case, comma, it may dispense with or relax the rule to such extent and subject to such conditions as it may consider necessary for dealing with the case in just and equitable manner. In the backdrop of aforesaid amendment and the provisions of relaxation,
Repeal.
huh?
Not
Repeal, not amendment, sorry, repeal, because it's repeal. We have used the word repeal earlier, but it's a repeal. The petitioner, though are having the requisite experience of 5 years as senior administrative assistant. However,
As well as B group also pass the B group.
that will not go for the B group will go later. In the aforesaid backdrop, though according to the petitioner, they are having the required qualification. That's why I use the according to them. According to them, they are having.
Otherwise, I can satisfy at least
No, will not go. Will not
if
go.
they were
They are
not
having the required qualification. However, for the proviso mandated under Rule 5 of the Rules 2019, they are deprived of such promotion for the reason that they are not having the graduation degree. And therefore, they represented before the respondent authorities to relax their educational qualification, inasmuch as it is their case that by virtue of the repeal rule or by virtue of the new rules 2019, undue hardship has been caused to them. Undue hardship has been caused to them, and equity and justice shall demand that rules are relaxed and their cases for promotion are considered. The cases for promotions are considered as promotion is a very valuable consideration for promotion is a valuable right. This is your case. This is your case. Yes. Yes. Such representation as is discernible from the record were considered by the respondent employer and and it is seen from the record that such representation or consideration were placed before were sent.
I mean, it was elaborately considered.
No. We'll come to that. Was initially sent was decided to be placed through a cabinet memorandum before the honorable chief minister, and subsequently placed before the cabinet memorandum. Subsequently,
That part, nothing has come up.
no, we are coming to it. Subsequently, the secretary, deputy secretary, additional chief secretary, after elaborately discussing had put a note on 2010-2021 The relevant portion is quoted here in below. The secretary is mentioned page 15. Okay, last date matter recorded. Let us mark this one. Blue sticker. Blue sticker. Only that paragraph. Pencil to pencil, not other. Thereafter, a decision was taken that as the petitioners do not possess the required qualification required qualification for the promotion to the post of superintendent, that is the graduation degree, comma, there the case of the petitioners were rejected as according to the respondents, this petition such claim lacks merit. Lacks merit. Such decision was notified through the impugn order dated 20. In the aforesaid backdrop, Mr. Setri, learned counsel for the petitioner, argues that the respondent authorities have failed to apply their mind to the given facts of the present case and thus fail to exercise their power properly in terms of Rule 16 of the Rule 2019. According to Mr. Setri, the rule of relaxation is required to be given a pragmatic construction so as to achieve effective implementation of good policy of the government, in as much as Rule 16 has been enacted to handle a situation of undue hardship as that has been created in the present situation. Therefore, only for the reason that petitioner's case cannot be considered for promotion in absence of education qualification is a result of total non-application of mind, inasmuch as it is a foregone conclusion that the petitioners are not having required qualification. Therefore, they are seeking a relaxation. Full stop. In support of such contention, Mr. Setri relies on the decision of the Honorable Apex Court in the case of Sandeep Kumar Sharma versus State of Punjab and others, reported in 1997, 10 SCC 298. Mr. Setri further contends that from the record, it is well established that similarly situated that of the petitioner, case of similarly situated persons, case of the similarly situated persons have already been considered by the authorities and they have already been promoted. However, the case of the petitioner has been rejected only on the ground that they are having not the qualification, not having the qualification. He further contends that the power of relaxation provided under Rule 16 is for the purpose of mitigating the hardship and total lack of promotion in a service career is a clear case of hardship. And therefore, such rule is required to be construed liberally. An arbitrary exercise of such power must be guarded against. In support of such contention, Mr. Shetty relies on the decision of the Honorable Apex Court in the case of Ashok Kumar Uppal and others versus State of JK and others, reported in 1988 4 SCC 179. 179. Okay. According to Mr. While concluding his argument, Mr. Shetty submits that in the aforesaid backdrop, the respondent have totally failed to apply its mind to the given facts of the case, and treated the petitioner in a discriminatory manner. Full stop. Par contra, Mr. Nayak learned. Par contra, Mr. Nayak learned counsel submits that relaxation, the power of relaxation is a discretion of the competent authority. The relaxation cannot be prayed as a matter of right. If a conscious decision is taken not to grant the relaxation merely because not to grant relaxation, merely because rule permits relaxation, no writ of mandamus can be issued directing competent authority to grant relaxation in qualifying service. He contends that the respondents have applied their mind to the given facts of the case and had took a conscious decision that as the rule has mandated for a definite qualification, such qualification shall not be relaxed in each and every cases. Otherwise, the enactment of the rule and the object thereof shall be defeated. Therefore, such satisfaction of the employer should not be interfered in exercise of judicial power of this court. In support of such contention, Mr. Nayak relies on the decision of the State of UP and others versus Vikas Kumar Singh and others reported in Swencho. Vikas Singh and others.
Other judgments are also there.
Huh?
Lordship is not disposing of.
No, not disposing. Just I am recording the.
Right.
Okay. Not disposing it. Otherwise, whole this time will go.
And in respect of the speaking order, Lordship, two more.
I will rely on not just we are concluding. We'll go on the next. Okay. Okay. Mr. Nayak further contends that but reason you have given, we are not doubting the reason. Therefore, this may not be necessary. Okay. Mr. Nayak further, while countering the argument of Mr. Shetty that the impugned decision is not supported by reason, is not tenable in as much as the order itself discloses the reason. Not only that, the department has produced the record to show that there was application of mind and there was a conscious decision. it is the contention of Mr. Uh, Nayak, then in certain cases where even the reason is not reflected in the order impugned, the court can very well go through the record and ascertain whether there was reason or not. Full stop.
Arbitrariness.
Ah.
Reasons are there, so it cannot be termed as
So,
arbitrary.
and accordingly, he submits that when reasons are available not only in the order itself but also on the record, there is no question of arbitrariness, inasmuch as this court should not sit over as an appellate authority in exercise of its jurisdiction of his exercise of his power of judicial review, more so when exercise of discretion under power to relax rule is dealt with. Full stop. Yeah, hard in part for further hearing on. No way out, Mr. Chetri. We have done our job. Do you want that today we should decide?
After issue petition. In the meantime, Lordship, two of the petitioners they acquired the degree Lordship and they were promoted.
That part already I have.
So that point is also
2% already retired. 2%
two
already.
retired, two got
And
promoted.
in
So
December,
even suppose two ways. We dismiss it, matter ends there. You are happy, you will have a retired life. Now you are in it under a tension. And other party, suppose we allow, what should be the relief?
to the at
What
least
should be the release? That at best, the relief should be that they have not applied their mind properly, so we can remand it matter back. At best, can we? Do you propose that we can give them relaxation?
that
That
point,
is totally ruled out.
since the pilot the in honorable court of the fact it is to consider for
That is consideration. Suppose we give
that part, my lord, at least people will retire happily, my lord, after getting
no,
this.
we understand.
the relief.
Suppose we give a direction that consider their case appraised because you have not applied your mind, upholding your argument. Okay, that can be given. Even if we pass that order today, that is not going to happen by 31st of
So,
December.
Yeah. But that is
So
what-
in that context, I am saying, that delivering this order today,
Yes.
or delivering the judgment,
yes, will not be put.
either it will
Because
not.
Lordship has come to know the intention of the authorities. So at least when Lordship will pass any order, either giving relief or not to give, the order has to be in effective. So that if otherwise Lordship pass the order, in favor of the
No.
petition,
Sub,
so effective must be.
ah,
Otherwise they will
See.
take the leniently. My lord. In earlier occasion they took the
no,
lenient.
that we understand.
That is-
This court you will get the order, direct order.
Yes.
Either dismiss or with a specific term. No
That-
hanky
that-
panky in between.
Yes. We know, my
Keeping the
lord.
record.
I'm keeping the record for the time being. Or can you give me those Xerox copies to me?
One step I have.
You give me that Xerox copies. The record is returned back to Mr. Nayak for the time being. Please give that so that I can find him. This is for the
Yes.
vacation homeworks.
Wait, Lordship is sick.
Fourth?
Okay.
Eh? You
After
can-
No, BB vacation we cannot
Yeah,
go because this is a part hard matter.
Yes. Again,
Part hard matter must be
In between, holidays are there.
no.
still till 1 month. It will automatically go out of. We have done so much. You just need to do 2-3 judgments. You may, if you want to rely that. So. More or less, we have covered your argument.
Yes, everything has been done.
That's why I have taken that judgment.
Then on 10th, Lordship.
10th.
Because
Budvar.
10th of January.
unless Tuesday,
Okay, on
it
Thursday.
should be Tuesday or
11,
Thursday, my lord.
11,
Otherwise,
11,
No, it will come at part hard in the top of the list.
11, Lordship.
11th.
It will be hit.
Okay, 11th. Yes, what is the name? Okay.
extremely sorry, my lord.
No, why you should be sorry?
Some of my
Be-
colleagues are waiting.
No, this bench is for hearing.
Yes.
We cannot jump like that.
Page 30.
Page 38 of the writ petition.
Yes. Page 37.
Page 37 is payment, not regularization.
The payment, your lordship, as regards the payment of the wages, the payable to the
Oh, you read it.
director.
The petitioner having appointed on daily basis for
Daily
a
basis.
limited period of 3 months
3 months.
to clear the pending yours cannot claim for regularization for service.
Which is the DO upon.
Then why are you relying on this judgment?
Your lordship, another repetition, the disposal for the consideration of regular.
You wanted consideration. Consideration also you cannot direct as on date. Your argument should be something different.
Another order, page 44.
It is filed by whom? He himself.
44. 45 or page 46.
Now what happened? Thereafter payment made.
Area salary, he got.
Huh?
Area salary, he got. Area salary, he got that.
How you propose to handle him? See, we know his right is very limited.
Look.
But at the same time, on record, it is that he has been working and you have imparted training by spending states, etc. Isn't it?
Yeah.
Now, give him the minimum scale of pay. In terms of Jagjit Singh, nothing more. You will not even under Upendas, he is not covered under Upendas, it's a daily wager. Give him that you have that instruction.
As per our
Because we are not in to pass this order that you consider.
Okay.
What will you consider? Law is do not permit you to regularize. Can we direct that you consider is regular?
In this connection, your lordship, I have already submitted the reported decision.
Of Uma Devi.
Uma Devi and others.
And who, what are the others? Where is the power to direct? What are the conditions in Uma Devi? Tell us. Under which conditions I can direct to consider your case
No.
or regularization? Which paragraph? Uma Devi, tell us.
I rely on the para,
Para
page 3.
Uma Devi, para
Page 3.
page 3.
Page 3. The service law, the casual, it is G. Your lordship.
Oh, no, don't go to head note. We do not really rely on head note. You go to the paragraph. Which paragraph?
Casual labor and temporary employee. Paragraph.
This is not paragraph, Mr. Talukdar.
Ah.
This is the then you read that headline. Okay, fine. You read that.
The service law. Your
Service law,
lordship,
yes, read.
the service law, casual labor and temporary employee, status and the rights of unequivocal bargaining power affect the class employee who do not have any right to regular to permanent public government. Further,
Stop here. So this is against you.
my lord,
The judgment you are relying on, even if you go by the head note, it is against you. Do not have a right. Do not have any right to regular or permanent public employment. Regularization means a regular public employment.
no, what happened with your lordship? Who by the process, government should give you the opportunity for regularization. That is my prayer.
No, you are relying on a Supreme Court decision. Supreme Court says that you don't have any right. Now, how can we say that no, you are having a right?
Another decision specifically.
No, we'll go to that first decision. Another which decision?
Department has already
Don't throw
considered.
him, bro. Throw him out.
Lordship.
You require him.
Lordship, can you see the page number 78, Lordship,
Hmm.
of our appeal?
Page 78.
A third decision.
We have not gone to second, you are going to third. Second, tell us the
Third.
second.
Third decision.
Already
Your
his application has been considered and rejected. Department. And
We know you have rejected.
Lordship.
Maybe rightly
It is
rejected.
Lordship,
AR to 2010 Supreme Court to 258.
What it says.
Korea.
ML Kesri.
Sorry. Page para number 211. Up to para 5. The employee the concerned should have worked for 10 years or more in duly sanctioned post or without the benefit of the protection of the interim order of any court or tribunal. In other words, the state government or its instrumentally should have the employee and continue him in the service voluntarily and continuously for more than 10 years. 10 years. The appointment of such employees should not be
What is the Tripura High Court judgment? All these issues were dealt in. My Lord Justice Akhil Qureshi's judgment. Okay, we'll take it after vacation.
Lordship.
In the meantime, I will take inspection whether he is working or not.
Already there is a admitted fact. I have filed the affidavit in reply. Affidavit in reply. Your Lordship page in affidavit in page 59. Already admitted.
আর file করে দেব। দেখুন, 2021 SCC online TRI Tripura 217. এটা লিখি লব Vasudev Devnath versus Union of India. লিখিত paragraph 6. You have relied on ML Kesri, no? Paragraph 7. What is your case? Now,
That are my submission. Umar Devi case also. There is page 13. Page 13.
Hmm.
E. For Constitution of India, Article 16, 14 of 309, public employment, temporary, contractual, casual, daily wage, or ad hoc employees appointed D-host. My appointment also D-host. I also left. D-host, the constitutional scheme of public employment, the right of long continuation of such employee on a irregular basis, but my employment is not regular basis. Still continue. Regular basis in the public employment if violated the rights under Article 14 or and 16. Here, such employee form a class of themselves. They cannot be claimed that they are discriminated against the vis-a-vis who those who have been regularly recruited on the basis of the relevant rule or claim to be treated on a par with the later service. Constitution of India, Article 16, 14, and 309, public employment, a temporary, contractual, casual, daily wage. It is my employment also daily wage at the rupees of 25. And other employees appointed the whole the constitutional scheme of public employment, rights of legitimate expectation, if any, to be the absorbed, regularized, and granted permanent continuation in the public employment on the basis of such relief has been granted to the similarly placed employee in certain order of the Supreme Court. Held, there is no such legitimate expectation, said the other overruled service law. Another specific.
It's in paragraph 58. Yes, read it. Hmm.
Para 53, proposed 53, 53. What is 42, para 53. One aspect needs to be clarified. There may be cases where the irregular appointment, not illegal appointment, as explained as be Narayana Power.
Okay. CAV?
Yeah.
CAV.
Look at,
Are you continuing?
Yes.
Still continuing? What is the standing regarding continuing?
as per our affidavit says 70. It's para 7. Is it?
Affidavit by Aurobjyoti Hazarika.
Yes, sir.
Page?
It's 70. 70.
Page?
70. 70.
70. Give me the judgment of Upendra's citation.
20.
Just a minute.
2025
Uh, just a minute.
2020.
2020
5 GLT.
5 GLT
605.
60. Page 70. No?
Yes, sir. No extension of order was
Pages are so careless. 64, 65, 66. Your affidavit is over at page 66. Where is your statement that you are working?
para 7.
What is their reply to this affidavit? Page 67.
Page 59. Okay. Reply.
Page 59.
Page 59.
reply to PDF.
With page 15.
They have made a annex a document saying that there is no extra writer in Lakhimpur
No, Lakhimpur, no, your lordship, Hemant.
at Hemaji. Sub-register Jonai.
Jonai.
Now, what is your stand regarding
Affidavit in reply.
affidavit in reply?
Affidavit in reply, there is, your lordship, there is specifically admitted.
Mm.
This letter, the sub-register Jonai,
Mm.
extra writer, Sri Govind Begu.
Mm.
Date of 15 appointment, date of appointment 15/09/2009. Was daily was basis.
Till date.
What I know.
Till date.
Till date. Now still I am working. Superannuation nil, STP candidate.
Now tell me, what is the date of this communication? 2014.
3/11/2014.
And when you filed the affidavit?
Our affidavit. Our affidavit filed on 17/2/2023.
You have the instruction.
Plus.
You should not throw him out of fear of the court or anything.
But we have also
If he's having ways, let him for a time.
Continue.
Have the exact instruction
Plus,
because
plus.
this is 2014.
14.
Heard the parties at length. Hardest parties at length. Though a specific stand has been taken by the petitioner and his counsel, Mr. Talukdar, that the petitioner is still working as a daily wage earner. However, the respondent has submitted that petitioner is not working. Therefore, a specific written instruction be obtained from the sub-register Jonai whether the petitioner is working as a daily wage worker or in any other way under the establishment of sub-register. But document says that he has been sent to different training during.
No, my lord, specific. There is a specific.
Yes, my lord.
What happened? Your lordship, I am filing so many representation after disposing the two petition. No, but at all consider. Only salary also.
Okay, list on.
Any date.
You give your date. So it is ball is on your court of 10 days.
I've already. 10.
10th of January 20. As part of I play.
How long?
There is a direction to file affidavit. We have filed the affidavit. And also we have filed an appeal against that order,
Against the
a lordship order of 18.
appeal is maintainable.
Maintainable or not maintainable, that issue is before the division bench. Argument had started for about 1 hour. Again, it will be taken up at 2. So my prayer is
Okay,
that
we'll
lordship
fixing it up on reopening.
reopening.
You argue?
Yes.
Let them have a chance. It is submitted by Mr. D. Saikya, learned Advocate General. Advocate General, appearing on behalf of the respondent that an appeal has been preferred against an order dated 18/12/2023.
Appeal number 2 of it.
Before the honorable file, which is registered as
Contempt appeal number 2 of it.
contempt appeal number 2/2023. 2023. In that view of the matter, full stop. in that view of the matter, let the present petition be adjourned and be listed on
8th of January.
8th of January 2024. 2024. The respondent shall remain present on the date at 10:15, subject to any further order that may be passed by the division bench.
Highly okay. While on last occasion, the department asked to produce the application. Was forwarded deputy commissioner also. We have the application. We have to forward it to the deputy commissioner on 2/2/2016 a lot. 2/2/2016. 2016.
Order dated.
No, Lordship, the application which we have forwarded to TLC,
Ah.
we were asked to bring the application because the application was not on record, Your Lordship.
Okay. Is item number?
3.
Compassionate appointment, my lord.
Compassion appointment.
My lord, the petitioner's father died on 2/11/2015.
Hmm.
My lord, and my lord, the petitioner applied for compassionate appointment
Hmm.
on 27/11/2015. And my lord, his district level committee meeting dated 4/7/2017, Borpeta district has rejected the candidature of petitioner on the ground, my lord, at page 35.
Page 35.
Well, 34, man. Sorry, 34. Serial number 12, my lord, down below. My lord, what has got it? 12, my lord. Serial number 12. Down.
By which order we have been asked to obtain instruction?
Order it
2011, 2020.
16/10/2023, Your Lordship.
My lord,
First around 16/10, thereafter again, we took time to take place this application, Lordship, because the application of the petitioner was not annexed in the writ petition, Lord.
Now, you have received the,
Yes, Your Lord.
what it say?
We were asked to apprise court on what date we forwarded this application of the petitioner to the TLC, Lordship.
Hmm.
We forwarded on 2/2/2016, Lord. We forwarded the application for completion of an outer petitioner to the TLC.
So you have forwarded it.
We have forwarded to a DLC and DLC rejected, Lord.
Now, why this application is necessary?
Because the
thing is this, my lord. Lordship may kindly see the grounds, man. My grounds of rejection.
Your grounds of rejection is that there is no post of pump operator.
No, and my lord, Lordship may kindly see my application now. My lord, my application is
When
there,
your
my
father died,
my father died on, my lord, 2/11/2015, my
let us take it after.
lord. My lord, kindly see, my lord, this petition, my lord, my application, my lord, at 21, my lord. I'm asking your lord, my lord.
No, it's not the trouble. I hope that my taking this matter will not create any trouble for you. Yes, proceed.
No, I am not eligible, my lord, that is all, my lord. My lordship may kindly see, my lord. This is a
Question of eligibility or non-eligibility, whether the period of compassion that should be is over by now.
No, my lord, I will explain that also.
Okay, then proceed.
I have that also.
Then proceed.
My lord, my father died, my lord, on 2/11/2015, my.
What is the principle that should be guided in case of a compassion paper? First,
My lord, it should be considered within a period of 2 years, my lord. My application was considered within a period of 2 years. My lord, my specific my lord, application is that, my lord, my application was rejected.
when it was rejected,
My lord, within time, my. Within time.
that is
My lord, within 2 years, my lord, and my lord, the person who is, my lord,
given, my lord, in my place, my lord. His application was, my lord, actually, my lord, should not have been considered because it has, my lord, more than two after it was considered after more than. My lord, lordship, my lord, lordship, my kindly see, my lord. I am not a little lost in the dispute, my case, my lord, because it is long pending, my lord, 2007. No point of, my lord.
No point of keeping it alive.
Dragging, my lord, my lord. If he is not, my lord, happy to.
You are frustrated carrying this brief.
No, he is also frustrated, my lord. I have to, my lord, answer him, my lord, why
He is frustrated because of us.
no, my lord,
Because of we are creating the hope
no, my lord, I'm, my lord, I'm,
where there should not be any hope in view of the finality of the judgment in Devabrata. It has gone a step ahead, saying that the delay in the court itself can be also a ground for it.
maybe, my lord, okay, on that count, my lord, my lord, but thing is this, my lord, this
You
person,
bear this brief for some more time.
my lord,
Please this matter after that. Go through this.
my lord,
Devabrata Tiwari versus State of West Bengal versus Devabrata Tiwari. Reported in SCC is not reported yet, Mr.
No,
AIR SC 1467.
AIR, SC,
14.
AIR, similar, AIR,
AIR All India Reporter, Supreme Court 1467. Okay. Here the principle, a new concept has been brought. It was already there, but all judgments discussed and summarized that the basic criteria is a beautiful word used, immediacy. When immediacy is lost, everything is lost. Now, what is the immediacy? Immediacy says it may be delayed at the stage of consideration, even in the court.
my lord, I'll try to define it.
Huh.
Because thing is this, my lord,
So therefore,
my has been considered, my lord. And my lord, I was illegally, my lord, lordship, my kindly
okay,
see, my
you
lord.
might have, but see, at the end of the day,
My lord,
suppose we'll hold that there is, that is also we are proposing and we are thinking.
my lord,
That's why, suppose, just listen to this. These are the ideas coming to mind of this court. Because you'll have to streamline them. It cannot be a source of appointment for years to come.
Yes.
The object is that the benefit is given to the family immediately in a distress condition. Immediate hardship. If you can continue for 2015 and fight a litigation till date,
Right.
you have survived.
my lord,
Just listen.
Yeah.
Listen. So, this is one aspect of the
Yes,
matter. Second aspect of the matter, the constitutional mandate of treating persons equally. Okay, suppose we hold that your case has wrongly been decided, arbitrary, illegal. We'll hold it to be illegal
Right.
and give you a compensation. Maybe for whole salary or maybe salary from wrong consideration. It's a liberty to you to will give a compensation under public law remedy with an option for you to file a civil suit and recover. That may be a new idea.
Yeah, exactly, my lord. My lord, because this
Because
illegality, my lord,
see,
otherwise, my lord, they will be
other
involved in, my lord.
other things are there. What is your
They will
principle?
commit illegality and, my lord,
What
go
is
on
your
doing this
principle?
judgment,
Suppose
my lord.
coming to the immediacy. Your provision is that a person should apply within a period of 6 months. 1 year. 1 year. And it should be vacancy should be filled up within a period of 6 months. No. Suppose if
we go by
okay, 2 years. Now, what is the period you have prescribed for a department to place it before the DLC? He is also before before the department. He is also before present. The officer likes his face. He sends the application made subsequently at the earliest and keeps his pending. What is the period? Okay, you send within a period. What should be the period the DLC should take up a matter? How have you divided these 2 years? Within what period DLC should take? DLC will take a matter after 5 years. How can we accept that? If your mandate is immediacy, what are you doing? Now DLC will take up it after 3 years or say within 2 years. It will send to the SLC. SLC will take up after 5 years. What is your prescribed procedure? Why in that background this case will be made applicable? Nobody is arguing it. All surrenders. Okay, he has also surrendered.
No, I'm not surrendering till now. I'm not.
Huh? What is your prescribed period? 2 years. 2 years means suppose 1 year, 11 month, 29 days. It is placed before SLC. Then, so if it is to be completed in 2 years, you prescribe time, or then we get hold of these committees and ask to pay compensation from their salary. Reject it. Reject it. I am not saying consideration. You will have to have a specific time frame. Then you say that we'll keep it in a waiting list, other department. When, how, what should be the length of that list? I'm not saying Mr. Dhar, your administration is not at all interested in dealing with it. For that reason, not only you are facing trouble, you are spending more money on lawyers, papers, printouts, in compassionate appointment than the payment that would have been made to these people. If we can decide these issues, High Court will be empty. Compassionate appointment. Just count it, how many matters are pending for compassionate appointment. And not only that, 5 years in DLC, then 3 years in SLC, then coming to High Court will remand back, again 3 years, 2 years, 5 years. What is the meaning? Where is the time frame? Let us fix for us also a date. It should not go beyond admission, compassionate appointment, and the government will have to file affidavit within a period of 3 weeks. Let the new year come. Yes, this should be your argument.
But my lord, my application has been rejected within 2 years. Within 2 years.
No.
And that too illegal.
That
And
will
that
be
is my
there.
specific
So therefore, you argue that even if I am not entitled for any service as on date, I should be compensated under public law remedy because it's a illegality committed. I don't have any remedy and bring those judgment. Will impose heavy cost upon this, and so that these people are a little bit their costs that no.
Well, these are lingering tactics, my lord. These are
No, Mr. Dhar, you are mistaken. We are not giving compensation on the measurements. We are giving compensation on the basis of illegality committed by you.
yes, exactly.
No,
That
therefore,
is here.
what he says is that my case is illegally rejected.
Yes.
Suppose we come to that conclusion that he is illegally rejected. His case is illegally rejected 2 years back. Okay. As on date, in terms of the judgment, immediacy is no more over.
Yes, yes.
So he has suffered that hardship for those periods.
Yes.
So compensate him.
Well, your lordship may kindly keep it part heard, my lord. Well, I do not need my lord anything. Well, even if it is dismissed, my lord. Lordship may keep it part heard.
No parted, but it will come. I'm
It
here.
will not come before your lordship. My lord, it will not come.
No parted. Already 18 matters have parted.
One more matter, my lord. One more matter, my lord. One more matter, my
Please,
lord.
this matter on after vacation. After vacation means tomorrow is the only day. 19th of January 2020.
All right.
Mr. Dhar, I have passed an order. I'm just correcting it. It may be uploaded today. I've asked the Chief Secretary to file an affidavit. Mr. Sutia was there on that date. I think it will be uploaded. All clarifying all these points. In that case, I have kept it as a part heard in that matter. That matter, I have kept it part heard. Now we'll expand this public law remedy in that case. And I have requested Mr. D. Nath to be present, and Mr. Sutia is already there representing the department. We'll upload that order today, and we'll have a continuing things in that case. Yes. This point also will include now in that case. Yes. Yes. We'll hear this after let the judgment be passed. Okay, then you come, we'll see that on the prayer of yes, Mr. Gupta, where is CGSC? So MS Bora is present, none appears for the none has represented the Union of India. Accordingly, matter stands and be listed after vacation. On evaded third week after Bihu. Huh? 25th. Yes, Mr. Chinna. Any compelling, is it a compelling case to be decided?
No, not.
Not.
Otherwise, also they are required to file the affidavit. But I must
Who-
admit the
Who
health
need to
department,
file affidavit?
health department. And
Okay.
I must fairly admit that these people are terminated as on date. Not.
Okay.
The only thing is that the area salary
Okay.
for the period they have worked.
Okay.
It's all.
As agreed to by what to say, hold health very dear.
So BP for us.
BP for this comma. As agreed to by learned council for the parties, this matter after vacation.
Keep them.
Yes. No time being today.
For 43 seconds.
Okay. As agreed to by the learned council for the parties, please this matter after vacation. In not after vacation, in the third week of January 20.
Item 10, Lordship. I have to file a affidavit of
Yes.
independent state.
The learned standing council for the health department prays for and is granted.
4 weeks time.
4 weeks.
After vacation.
They want their salary. They ask that they
Yes,
will give them.
Lordship.
Huh?
The P. Gugoi is appearing in this case.
3 weeks, 3 weeks, 3 weeks.
But-
Yes. Not end this year with this dismissal. None appears for a petitioner at all. However, interest of justice may trust bench adjourn and be listed after vacation. Yes.
Lord, matter pertains to completion and appointment. Lord,
Hmm.
you kindly come to case 12.
Affidavit file
Yes, ma'am.
is
Respondent number 1 has filed the affidavit.
when died
Lord, on 24 2007.
24/7.
2007, ma'am. Thing is that, my lord,
We'll take it after vacation.
for the post of constable, my lord,
But my proposal has been given for grade 4.
No, tell me, suppose we allow, can you be appointed as a constable up in the year 2020,
I am also
Three.
enclosing the minutes of the
2023?
Hello.
Will be fit to hold a gun. We'll consider all this after.
They have
As agreed
wrongly
to by the
rejected.
learned counsel for the parties listed.
See, we both are agreed, my lord, may after verification.
Fine.
Okay.
As agreed.
Oblige,
After
Lord.
view vacancy.
Keep your
What is the issue?
Regarding lordship, compulsory time, any problem?
may please your lord.
Hmm.
Lordship, this instant writ petition has filed for not declaring the result of the petition.
You appeared in which exam?
In CRPF
What is the state then?
Okay. Everything is, we have disclosed lordship, my annexer D, running page 56. He had
Running-
received that he could not qualify because of height and chest measurement.
Case 56.
Page 56. Affidavit page 40, annexer D.
Annex D, yes.
Yes. He had received his signature is there, lordship, we have intimated him.
Water carrier, name,
What?
trade, name of the candidate.
Swadesh Bhuj, his height should be 165, but he is 159,
159. Not qualified.
not qualified. And this is he received.
Hard. That's all. It has become infrastructure. We'll close it. The present writ petition was filed. The present writ petition is filed. Praying for a direction to the respondent authorities to take an appropriate decision in respect of the participation in the process of selection undertaken for the post of CTW/water carrier and to declare the result of the petitioner, comma, as the same, comma, according to petitioner has been withheld. Full stop. An affidavit has been filed and affidavit has been filed wherein a specific stand was taken that the candidature of the petitioner was rejected on the ground that the petitioner's height or what?
Yes, Lord.
Height was 159 centimeter,
Yes,
159 centimeter, whereas the minimum required height is 165 centimeter.
And also, Lordship, second page, test measurement.
Okay. The further ground for rejection of the candidature of the petitioner is chest measurement.
We should be 78 to 83, but his is 83 to 87. Here it is more.
Okay. Where is? So you say that these are not muscles. Okay, let us not go to. And that his chest was above the minimum required. In that view of the method, nothing survives in this distribution to be adjudicated accordingly. The same stands closed, being in practice.
That may be taken clarification.
Okay, the prayer will and concept for the method stands adjourned and be listed. Yes.
Hello.
Lord, in this case, the last occasion, municipal authority produced record, Lord. They are- the record.
Have you gone
I
through
did
it
not get. Lord, let me take about 2.
after vacation? Uh, though Mr. Dasgupta learned counsel for the learned senior counsel for the petitioner is present, however, none appears for the Guwahati Municipal Corporation. In the interest of justice, matters stands adjourned and be listed on event.
The third date mechanism, right? 2024, is a, that is-
Read,
that is-
title, okay. When? Before that.
Yes, come.
Yes,
Look, it is not like
give a date, because record is, I have seen the record. You can show him also.
No,
Huh?
not required. Not
Huh?
required. The date of birth was recorded in the year 56,
Huh.
and accordingly he was retired in the year 2016. Then he approved before the municipal authority. You see, it is contrary to my birth certificate. Municipal authority has rectified it. It should have been rectified in the year 1964. Despite that, they have rectified it in 1961, and that is why he has been made.
Okay, well, after vacation, we'll take it.
That is a simple case. Sir. Nothing.
Nayak is here, but after vacation.
All are no
Okay,
problem.
give a date early part. 12th of January. 2020.
I thought there is that from LDA based on promotion to UTA, but he raised an objection that our original post is personal post. So that is why we are not getting the promotion. So, but our case is that by election process,
This is important issue.
Lots of impact.
This is important because your argument would be that already law is settled
Lot.
that when it is a personnel post, there is no scope of promotion. That has been upheld by a single bench. Then it was decided by a single bench, coordinate bench, and it went up to division bench. Now division bench had upheld it. So there is no scope. Now the second question will be whether in the given facts of those cases, it is covered. In those cases, it was a specific mention in the appointment order that your post is personnel and no promotion should
Page
be.
29, Lord.
Huh?
Page 29 of the read petition.
Page 29.
Of the read petition. The posts are personnel of the incumbent concerned who are holding the post and will be abolished as soon as the concerned incumbent relinquish their post in any.
In those judgments, similar appointment.
but my lord, in page my lord 34, they have initiated a selection proceeding that is not unchallenged, still unchallenged, and my appointment is unchallenged from 2007 to 2023.
No,
And
no.
selection
for what?
for this filling the post of grade 3 LD. Because
See.
we are,
What they say is, see, our hands are tied.
I understood.
Our hands are tied. I might have a view that there cannot be any question of any post can be personnel, but service cannot be personnel. It is when a service is regularized, the meaning of regularization is you bring that man to the regular government service under government. If his service is under government, he is entitled for all benefit under service rule.
Otherwise,
There is no provision in the service rule to exclude him from promotion. Yes, for the financial reasons or for any other reason, government has taken a decision that your post is personnel. Because after your retirement, we will not fill up this post
yes.
through regular post. So it will not be brought to the cadre. It will not be part of the cadre strength. That will not mean that you are not a government employee. This is my view, but my view is has been overruled by the division bench. So I am bound by a division bench. What to do? Dismiss today?
No, my lord. I have to show, my lord, the division bench has said that you regularize him within 3 months. They have not done it.
They have
Division bench-
regularized him,
Yes,
therefore they have personnel post.
Earlier,
And this was irrigation department.
Lord.
Yes.
And that case, by my Lord Justice Huya, as then he was, I think his single bench, it was his decision.
Lord.
It
Yes.
was a irrigation department and similar appointment.
what are the
Water resources. It was a similar. So I cannot disagree with the
Yes.
view affirmed by the division. There is a
My
judicial.
only query is, my lord, but I understand that whether retrospective effect is given or not, because 2007.
Okay, you can argue, no
Yes,
problem
yes,
on that. You can argue after vacation.
All right.
This is the issue, I think.
Yeah, yeah,
As
yes.
so far I
Even lastly, we have reverted back some persons who were promoted, Lord. And this person came before the Honorable Court. That was upheld.
yes. Yes, tell.
For item 18, my lord.
For item,
18, my lord, I
yes.
appeared for APDCL. But
Ah.
my senior was on legs on another court.
Okay, Justin, as agreed to by the learned.
Pending on highly of that.
I mean, definitely. Yes,
Well educated. Upgraded. Yeah, comfortable.
what do you say? Any urgent matter?
No, certificate,
All right.
item, fine, and I spoke to another country.
No, we'll wait for you. Why are you? Item number?
21.
I'm a private respondent. I'm officiating as a principal, so the matter can
Why did he before this bench?
Because,
not by my lord.
my
Mr.
lord,
Nayak,
Mr. Nair,
Oh, Mr. Nayar is not here.
my lord,
So what to do today?
the only thing is that education department has to file the affidavit.
Okay,
Hello, मैं आपका purification.
okay. Mr. Gogoi, Learned Counsel for the Education Department submits that he may be granted 3 weeks time to file
Not
affidavit. Prayer is allowed. List this matter after. Yes. Just a minute, just a minute. Anybody? 22. What is 22?
One partner hearing is there.
Huh?
Partner hearing.
No, part third will hear it too. No problem on that. If anybody do not want and want to wait till 2, that's why I am sitting. Yes, 22, call 22. Part 2, part third will take up. No? We cannot say non-APR, 1 is over, then 23. After Sunday at 2, okay? 24. Yes, Mr. Deka.
My lord, today, my lord, a similar matter was accepted for court number 5, my lord. And all the matters have been said on court.
Okay,
So this can make
okay. It is submitted that similar writ petitions have been fixed on 4th
4th
of
of
January
January.
2023. 2024. Accordingly, the present writ petition be also listed on 4th of January 2024 along with
4776 of 2023.
4776 of 2020.
I'm sorry.
Only how many matters? Hearing and 2 leftover matters.
Few of the board resolution. The lordship, so please, I may also be served with a copy.
Definitely.
I'm giving you.
It is in your favor, isn't it, Mr.
No, my,
Sharma? It's 199.
my lord, these are 199 master workers who were working in KHLE project.
Okay.
They were not working in KHLE project.
We are similarly situated in some other.
Okay.
We have been appointed from
What
period.
what is the subject matter of this writ petition?
Subject matter is lordship, we are claiming parity
Hmm.
in payment of death cum gratuity benefit,
Hmm.
like those granted to 199 workers of Karbilanpi Hydel Power Project.
Okay. Now they say that, but this resolution is not supported by any reason.
My lord, may I just submit?
You have the record with you.
Okay.
Because see, here you say that we have considered a proposal placed with financial application and thereafter approved the payment of what is the principle?
Yes.
That principle is not there. So as to make a determination. Isn't it?
Yes,
They are seeking a parity. Your decision, board resolution reflects nothing. Only you considered financial implications and paid it. Now, what was the basis of giving to somebody? What was their criteria?
The
Please.
lordship, the criteria is there is a Assam government circular
Lordship may kindly see Annexure 7.
No, therefore, what is their
They have
Entro-
adopted that circular mutandis mutandis.
Oh.
Exactly.
that? Where do you get that?
It is Annexure 7. Sorry.
Can we decide this matter today?
Yes, we can.
My lord, may I just submit here?
Yes.
What has happened their entire service got regularized. And they were brought into a new pension scheme from 2014 onward. And before that, they were all outsourced meter workers,
Okay.
not direct employees.
When,
Whereas
when,
this
when they were appointed, bring to the regular fold,
2004.
2014, my lord.
and
My lord,
when is your employment?
the appointment orders are from page
No, 2004 they have come into the regular fold.
14.
2014.
Yes, my lord.
Now, what is the new pension scheme in your case?
My lord, it's a similar like the government of
Government of Assam. According to them, in the scheme of the government of Assam,
there is no
the persons who work master roll and regular, their case would be excluded from the new pension scheme. This is your case, and they will be in under the
There is a
old
government circular. Lordship
government
may-
additional circular.
Yes. Lordship
Okay, we'll take up this matter after vacation. It will have a far-reaching consequences
my lord.
if we take in your favor also, against also. Because if I have not gone through the brief, what we could understand is that you have adopted the pension scheme,
New pension.
scheme, as per the in terms of the government of Assam notification. Similar. Now, government of Assam, after adopting that pension scheme, issued certain clarification
Right.
whether that entry into service, so far I remember, entry into service will mean a fresh entrant or the master roll workers who are already continuing. A clarification was made saying that this will not be applicable so far relating to the master roll and all. So therefore, they are claiming that this is covered by, we are also covered by new pension.
Lordship, our case is that we were initially appointed as master roll workers. There is a circular of 18 March 2010 of Assam government, which says that irrespective of the date of regularization, first 6 years would be deducted. First 6 years of service will be deducted.
Sanchita.
Yes, and thereafter,
Hmm.
that remaining period will be counted towards payment of pension and death cum retirement.
Hmm.
Assam government has adopted that circular in 2009.
That was challenged in Sanchita Roy, there is some discrimination. Is that it?
Yes, my lord.
Then
Okay.
Sanchita Roy, it was allowed to a limited person,
Yes,
then it
ma'am.
went to the division bench.
Yeah.
Division bench uphold it, and therefore the 6 years deduction has been now wiped out.
Yes, my lord. My lord, and
Isn't it?
I'm not sure.
that is a
That
judgment
is
of
the case.
yes, my lord. Yes.
So if therefore your case will be I am also covered by the judgment of Sanchita Roy by the
Yes.
division bench.
Yes.
So therefore I am entitled for pension.
My lord, but
So my death should be considered prior to 2014. So I will come under the old pension.
Because I was appointed earlier.
no, my
I
lord,
was
there's a difference.
appointed in 89.
One moment, Mr.
No. We are, don't worry. We are taking up this method. This is not a method to be decided like this.
Yes, ma'am.
We are in a midst of a part hard method. We'll hear this.
After
That's why.
vacation, Lord, please kindly give a pic.
Okay, we'll give a date.
My lord,
Your case will be that no, they are not.
no, we have not adopted every of the office memorandum because we are a APDCL. We don't have to adopt everything.
That is
Yes.
that will we accept. You will have to sue us.
Yes, ma'am.
That see, this is the our principle. We are not bound by the scheme of the Assam government until and unless we adopt.
Yes.
And we have adopted this. This is our principle.
Yes, ma'am.
So under this principle, they are not.
Yeah, ma'am. My lord,
That's all.
my lord, may also the record. That would be better for. I
Okay.
would have a
Oh.
look on.
You bring it. Why should we?
No, my lord,
The standing
because-
council.
My lord, it is in why we write the letters with the order of the court. It's more. It comes quickly, man.
Though Mr. S.P. Sharma, learned counsel for the respondent APDCL, has produced resolution number 21 dated 20/06/2020 in terms of this court's order dated 14/11/2023. However, for the determination of the controversy in proper perspective, in the considered opinion of this court, the records pertaining to such resolution and decision shall be necessary at the time of hearing. Accordingly, on the next date fixed, Mr. Sharma shall keep the aforesaid record ready with him. Okay? Please this matter on
My lord,
1st of February.
Lordship, some of the petitioners are retiring. Two of them, one has died.
You will get area. We know all these are anxieties are there, but what to do? So many matters are there. Humanly not possible.
Leave it to your.
my lord, the instruction, my lord, is putting the
You can take it back also. The instruction received by Mr. Sharma is returned back.
With we request the instructions whether our results should show clear the ground that our
Uh-huh.
biometrics have
Some more time required, Lordship.
What is this?
connection. They're withholding the
Dodger.
results. They cannot say why.
They have to bring dodges from different.
No. We want to know
Yes.
whether it is for the biometric or for other reason.
Yes.
You know it. Why you have withheld it?
They have to check. Here they.
Then he will come with from Delhi.
No, Lord.
Who will give you instruction? Tell me. Don't make this kind of submission that they will have to check and they don't have time.
No, they have inspected and dodgers have to, 16 petitioners are there and their dodgers have to check. And some more time they communicated with me that some more time required.
Okay.
So
We are
we have,
giving. Huh?
4
only,
weeks,
only what I said
4
that
weeks
is
time.
a list of 1,337 candidates they've separated out to withhold the reason. From
They
that
know.
list, they just have to say this is the reason.
What is the
Here
For other
in
reason, I
the
want
selectors they have written in 1145. But it is- and,
1137.
not
Those are the candidates. I'm within that.
But look into this
for-
moment, it is if we allow this repetition, we may impose cost and with all consequential benefits, even salary, back wages. If this is this is a simple instruction that for this reason we have
Yes.
withheld.
Yes.
That there we want need to check their biometrics or not.
biometric.
That's all. For that, if you need so much of time, we'll ask your officer to be here with the record. We'll see. This is not the way.
4 weeks time.
MS Borua, learned CGC.
Yeah.
CGC.
Yes.
Is granted a last chance to obtain instruction in terms of this course order dated 13/12/2023. If no such instruction is furnished, this court may order for personal appearance of the concerned individual, inasmuch as it is submitted by MS Borua that the respondents require more time to verify, more time to just intimate this court the reason for withholding the result of this petition. That much you need more time.
Okay. Okay.
My lord, I have communicated with your client, my lord. They're praying for 2-3 days time to get back. My lord.
Fourth, third,
4th or 5th.
fourth.
Let it be on fourth. Let it be on fourth, madam.
Fifth. He's saying fifth.
Friday.
Friday.
I think my friend was indicating, my lord, 18th or 19th. My
Madam, not feel like a first. It all dictates-
So suppose if your case is considered or taken note of, you are protected.
My
then
lord, yesterday I could lay my hands to a judgment of the Supreme Court where appointments made against personal post also, there is no bar for. That's why, my lord, I want to make some substantive argument. Let it be on 18th. Well, I can place the judgment. No?
Let it be there, my lord. Only declaration of the result.
No, I'm looking at the larger picture.
no,
Not
that is I'm also interested
Huh.
a little bit on that question of law.
Yes.
We had a discussion a little bit earlier. My view But I'm bound by a.
Only thing Supreme Court said that two separate seniority lists has to be made. One for the regular courts and one for this court.
No, my idea, seniority will come later on. My ideas, what Supreme Court says, I do not know. My idea is moment you regularize a person,
Exactly. I do ex-cadre, I'm part of the cadre.
you are part of the cadre. Moment you are part of the cadre, how can your right for consideration for promotion even be wiped out?
All right to employment includes right to appointment and promotion both. There's so
And
many.
other parties, the personnel object of personnel, this is my view.
Yes.
Object of creation a personnel post is that government is predetermined that we will not fill up this post after you retire.
Exactly. But during my service tenure, how can I be
That
denied
will
the
not
benefit?
relate.
Notification has come and they have entered into an agreement also.
No, that is it. No, this is
No,
we are
I'm
not
the
on
larger
object.
issue.
Larger issue. We are dealing with. We are facing with this
Well,
issue time and
I
again.
think this is an issue where Lordship should give a pronouncement covering all aspects. Maybe it will go against us, maybe it will go against in our favor.
It will be pending. Only the declaration the result.
Okay, we'll see on what.
18th, my lord.
18th will be too late.
Too long, Maharaj. Because
Are you having any problem?
we have no
No,
engineer.
no, but I'll have problem after 18. That's why I said.
So before, let us have why
fifth,
why
my lord,
Mr.
let it be
Patwar
fifth.
insisting
Okay,
on
okay, okay.
fifth.
Let it be on 9th, my lord.
9th? No, we are just 9th.
Or 8th, 8 तारीख है?
Already 7 meters are there.
8
17.
8 तारीख है?
What we are trying to do is all old meters, those which can be displayed, trying. So all meters.
17 तो बंद हो जाता है।
71.
50 is why 50 you cannot.
Okay, my lord, let it be before. Okay.
Fifth will try, we'll give a try.
Deep blue.
As agreed to by the learned council for the parties, please this matter on 50.
It is better, my lord. I have gone through your lordship, sir. Actually, my lord, it is covered. I have seen the fact, same fact, but I, being a government worker, I cannot consider all these things.
Okay.
But up to what extent we can oppose it? I have gone through your lordship order. It is a good order. Accordingly, lordship can dispose of the matter by same fact. I have seen.
The 311.
311 2B.
2B.
I have seen your lord.
I tried to.
Yes, yes,
Yeah,
so
because
actually only one case was that was a referred Nemar case. Nemar case, what happened, my lord? During the process, two persons were retired. Then,
Hussein Ali. Now I recall the judgment.
the court.
Is it
yes, yes.
reported?
No.
Not.
Then what happened, my lord? Two persons were retired. Then court direct them till their for the purpose of inquiry only, they should be deemed to be, my lord, innocent. In this case, my lordship, he is in service, no doubt. He is now dismissed. So, pursuant to your lordship order passed 6467/2021, the facts are same one. So, this is a misconception of the officers. They are say not necessary, but he said you are to say incapability to inquiry. Why there is not practically possible to inquire? That is not the misconception. They say that you already proved, already so and so, you are not needing this. That's why it is necessary. Exactly, Lordship said it is point that on merit. So nothing more to be, no, nothing more, my lord, I can, my lord, argue this matter. So what can pass order? Same.
But not. You will
But
not get.
only one thing, my lord, my parent
No, I'll record all your objections.
objection.
Yes,
Only
I-
one thing I also, my lord, when directly them, my lord, respondent also direct them to take as per law immediate. Because man should not be in this type of man, it should not be in the police. Otherwise, they will see about the matter. Oh, court has ordered registered, they will do nothing unless I send a letter. So, lots of that part may be lots of
What to do? Keep it after vacation?
Yes, sir.
Huh?
Yes.
Hard in
Part.
the hearing could remain inconclusive. Accordingly, release this matter for hearing on.
Any date.
So we just will a formal declaration.
January, my lord, 11.
11th of January 2020. Give a note of your fact by tomorrow.
Yes.
Huh? What are the facts? Which are the annexes?
Yes.
That's all. And when were charged, when dismissed, what is the reason for
Yes.
dismiss?
Right. Yes.
And so far record is concerned, lordship can see the record. That not. Obliged.
Yes, Majumdar.